history of capital punishment, dating back to the early days when colonizers crossed the Atlantic in their quest for freedom and religious liberty. Now, they may have left King George in Great Britain, but a custom that they didn't leave behind was the death penalty. In the beginning, capital punishment was ubiquitous. Any crime was punishable by death. And in the 1960s, it shifted to discretionary-based sentencing. And by 1972, the Supreme Court struck down the death penalty because, according to the Equal Justice Initiative, it looked too much like, quote, vigilante justice and lynch law. Add in wrongful convictions, cruel and unusual punishment, arbitrary application of capital punishment that targets black, brown, and economically disadvantaged people, and then there's no question why so many people want to see a practice that is inherently flawed, expensive, and defined by bias and error eliminated. Ngozi Ndulue is the Deputy Director of the Death Penalty Information Center, and she is here to speak with us tonight and break it all down about capital punishment and how it's been prescribed in this country. Ngozi, welcome so much to Amplify. This is a conversation that I don't think we have enough of, so I'm excited to have it with you because we know that capital punishment has had its grip around the U.S. justice system for quite some time. And how has the federal government and the states really embraced this practice?
Well, what we've seen is that there was really a peak in the use of capital punishment around this tough on crime era where we know some of the laws that have really increased the number of people incarcerated and increased the number of people serving long sentences happened. So in that mid-90s era was really the peak of United States capital punishment. At that time, we would have almost 300 new death sentences a year, almost 100 executions a year. But what we've seen is that people have realized that capital punishment is not making communities safer, has significant systemic problems around race, around arbitrariness, around poor representation, and people who have disabilities and other issues that are being sentenced to death, and around innocence, where we've seen innocent people sentenced to death. And with all of that, we've seen really a growing a reduction in the use of the death penalty, where we have, less than 50 new death sentences a year for the last, more than 5 years, and we have less than 30 executions a year, same way. So compared to the peak.
Yeah.
Oh, so I was just saying, compared to the peak of the death penalty. Before we go ahead
to where we are today, I'm just shocked I'm still stuck on what you were saying about how it peaked in the 1990s. And I don't want to jump ahead and miss that point because, in this show, we always talk about the policy climate and the politics of an era and a time. And I wonder if you can just tell us, why did the use of the death penalty peak in the 90s? And I'm just thinking about the fact that there was a Democratic president during that time. So is there any context you can give us to what all was happening? Is it war on drugs? Is it like what was happening during that time?
Sure. I mean, the war on drugs is connected there. I think there were kind of there were higher crime rates, so there was some legitimate fear of crime. The problem is, though, that we know that the death penalty has no kind of effect on whether violent crime happens or doesn't. The National Academy of Science has kind of gone through all the research and said that the death penalty really doesn't have a deterrent effect. We have no evidence of that, right? So, but at the time there were significant concerns about crime, and there was a different political environment where people were, advertising their toughness on crime, where we had these federal bills that were being passed that were really reinforcing longer sentences, reduced review, reduced ability to go to the courts, that their effects are still resonating to this day. The Anti-Terrorism and Effective Death Penalty Act was passed in 1996. And because of that act, there are people who, when courts have said, actually, this person has an intellectual disability, we can still have, and that is supposed to make them exempt from the death penalty. We still have people who have intellectual disability who are being executed today because of laws like EDPA, the Anti-Terrorism and Effective Death Penalty Act, that put these kind of procedural blockades. And they say, sure, by current standards, by constitutional standards, you have an intellectual disability, you're exempt from the death penalty, but you brought your case earlier when the courts were applying an unconstitutional standard that was based on stereotypes of what it means to have an intellectual disability. And sorry, you can go ahead and be executed. And we have several people who have been executed over the past year where there's really strong evidence of intellectual disability, which should, by the United States Supreme Court's ruling, stop them from being executed. But it's all of these kind of procedural rules that many of them that were implemented during this time that are allowing these executions to go forward.
Okay, I want to explain, because this is all really complicated. So I don't want to just I want to pause for a minute and help people understand what exactly we're talking about here with the laws and the policies, because I think this is something that we don't talk about enough. And I don't want to rush I think our context here. You started to get into a bit about the constitutionality and the legal challenges, blah, blah, blah. But back up for a minute, because it wasn't until the 1960s, even though there's always been some kind of abolition movement to get rid of the death penalty, in the 1960s, we saw that the constitutionality of the death penalty was actually challenged. And if you could talk to us about on what legal grounds it was being challenged and what in the world the Eighth Amendment is and had to do with it, just so we kind of understand the legal framework that we're working under.
Sure. And I think we need to thank the NAACP Legal Defense Fund for a lot of the groundwork that was laid for the constitutional challenges to the death penalty at that time. And what had happened was that there was all this work around civil rights, working to end Jim Crow in the South. But at the same time, we had these very highly publicized trials of Black men in the South, often accused of rape or of white women. And because of some of these trials where there were some really transparently unjust outcomes that were also a mix of the formal criminal legal system and racialized violence, mob violence, lynchings. Some important examples there are the Scottsboro boys in Alabama, the Groveland Four in Florida, where we see this kind of intersection of kind of police complicity, show trials that were really not really tuned towards finding justice, but actually just kind of expressing communal rage. And when LDF saw that, they began working on these cases. They began sending lawyers to work on these cases, and they saw that there were broad problems across the criminal legal system in the South, but actually across the country. And in doing so, actually started documenting some of the procedural issues with the death penalty across the country. So during this time period, there are challenges to the death penalty based on race, based on just the lack of due process in these trials. And they kept coming to the United States Supreme Court, but the United States Supreme Court was not ready to make a big pronouncement. So then in 1972, in Furman versus Georgia, the United States Supreme Court finally takes on this case about the constitutionality of the death penalty and finds that the death penalty as it was applied at the time was unconstitutional. And this was a very divided court. We had 5 different opinions. This is one of the longest opinions that sets of opinions that the United States Supreme Court had issued at the time. And what happened is that there were some justices, like Justice Marshall, who would say that based on the Eighth Amendment that protects people from cruel and unusual punishment, the death penalty in all cases is unconstitutional. That wasn't the narrowest holding, though. The judges were able to agree that as applied at the time, the death penalty was unconstitutional. And what people take from those many opinions is that because it was being applied in an arbitrary and capricious manner, you couldn't tell the difference between a death penalty case and a non-death penalty case. And some of the justices noted if there was any difference, the difference was about the race of the defendant or of the victim. And that stopped the death penalty in its tracks at that time, but it was soon to be resurrected by new laws that states passed to try to get
pause right there. We're going to be right back. I got to go to a commercial, but Paul, I need you to pause right there because I have like 10 questions I want to ask you. And Ngozi, we're going to come right back and keep talking about the contours of capital punishment and the death penalty, and specifically the racial bias in it all. Our conversation is going to continue. Stay right here on Amplified, only on BNC. So before the break, we were talking about the messy and convoluted history of the death penalty in the United States. Like most systems, it just reeks of racial bias. The Death Penalty Information Center published a report just last year that contextualizes the injustice that Black and brown people endure under capital punishment. Ngozi Ndulue helped author that report, and she is here with us. She says that capital punishment has been used to enforce racial hierarchies that are, quote, the apex punishment in the American legal system. Ngozi is here. Glad to have you back, Deputy Director of the Death Penalty Information Center. I want to jump back into this and to talk more about your report. First of all, if you could just also level set a bit for us about what we mean when we talk about the death penalty and the methodologies that have been used and how they vary, frankly, from state to state.
Sure. What we see is that the most common way that executions are happening is with lethal injection. But as drug manufacturers have objected for their drugs to be part of the lethal injection process, states have actually started going to more kind of, visibly gruesome processes, such as firing squad as a possibility, reinstating the firing squad as a possibility, going back to electrocution. We just saw some of even in lethal injection, which is supposed to be seen as a more humane way to be executed, we just saw a really brutal, visibly brutal botched execution in Oklahoma at the end of last month when John Grant was convulsing and vomiting for 15 minutes before he was, or during his execution. So we have continued to change the way the executions look to make it kind of sanitize it. However, because of the methods that are being used, that we're still seeing these kind of gruesome, torturous deaths that are happening. And some of the ways that the drugs work, sometimes you don't see that because if you have a paralytic, you might not see the pain.
So let's jump to the real racial disparity of this. I think it's striking that lynchings ultimately started to decrease in the 20th century. Mid 20th century or so. As they started to go down, we saw that executions and capital punishment started to go up. So can you talk to us a bit about that phenomenon and how executions ultimately took the place of lynchings in the 20th century?
Yes, lynchings and executions really went hand in hand in many places. So there were times where because of campaigns by anti-lynching advocates and groups, there was too much attention to lynching, international attention to lynching, and local communities would say, well, we can assure a speedy execution, so we don't need to have a lynching here. Or there were times where there were death penalty abolition bills that were being considered, and people would argue, well, if we abolish the death penalty, then we're going to have more lynchings, and that's just not great for our public image. We think about lynchings as something that, was kind of more spontaneous, that was not officially sanctioned. But oftentimes it was either explicitly or implicitly sanctioned by people who were in control, judges, sheriffs, local officials. And seeing that today, we still see that shadow of lynching, even in cases that are currently going on, where there have been, jurors who have made statements that really said, we should just, shoot it, a juror statement in Julius Jones's case about we should just take him out back and shoot him. So there this idea of this kind of extra legal violence and this role of retribution that still lives on in the capital punishment system till this day.
Now, I know that you wrote a report that is has evidence in there that supports the idea that there's racial disparity in the system. And as I look at, I think we had a chart that we were putting up showing the racial breakdown of people on death row. And it looks like there are a lot of white people on death row, too. So if you could talk to us about the ways that the system is actually discriminating against black people and the evidence that you highlighted in your report that really proves that there's racial bias there.
Sure. So we're seeing a number of things. One is that if we're looking at who is on death row, we still are seeing a much higher percentage of people on the nation's death row of Black people than they are in the population, right? So we're still seeing disparities as far as people who have been convicted and sentenced to death. We're also seeing disparities about the crimes that people are being sentenced to death for. So if you have a white victim, you are much more likely to have a death sentence. And so what that does in some ways is actually put more white people on death row because most crime is intra-racial. There's no, use in talking about black on black crime because most crime is black on black or white on white or Latinx on Latinx, right? So when people are segregated, they commit crimes against people who are closer to them. So what we find is that the number of people who have been executed, who are on death row, who have white victims, is much higher than you would expect. We have about 50% of homicide victims are white, but about 75% of those of cases that ended in executions have white victims.
I'm curious, this is a state issue. There's a federal aspect to this issue. Are federal executions as frequent as state executions? And are you seeing that same kind of racial bias and equity happening there too?
Federal executions historically are very rare. In this modern era, after that Furman decision in 1972, before this time we had 3. Before the last administration, we had 3. But between 2020 and 2021, there was just a string of execution after execution after execution, 13 federal executions. So, this was the first time that the federal government had executed more people than the states. And there are so many ways that this was really a historical aberration, this string of executions. But the federal executions actually demonstrated that some of the same issues that we see in state executions, which are much more common, happen in the federal system. So the same thing about racial bias, the same thing about people with intellectual disability, with serious mental health issues being executed, the same thing about these procedural roadblocks that would stop even evidence that was hidden from the defense from being considered because they say, oh, sorry, those procedural laws, stop that. Although that they are rarer, we know that there are the same problems, and even sometimes less review happens in the federal courts because you don't go from first state court then federal court. You only stay in the federal courts. And so this is one of the reasons people are talking about commutation of everybody on federal death row and other and bills are being considered about abolition of the death penalty at the federal level.
As we're having this conversation and you kind of brought this up a bit, I'm thinking about Oklahoma that just executed John Grant. Actually, early and just went ahead and executed him because he didn't choose which way he wanted to be executed. So they're like, we're just going to do it our way. And thinking about, is it Julius Jones that is also on death row there, that is awaiting. And I wonder, as people are trying to fight and push pause and, get some kind of other process or other due process for people who are sitting on death row, what actually works to delay or even stay these executions?
Well, there's motions that are being filed in the courts for Julius Jones' case. There has been a positive recommendation, two positive recommendations to commute his sentence to life with parole. So there's definitely advocacy there. We've also seen a succession of states abolishing the death penalty. Virginia just did it this year. So there's a lot that's going on in advocacy in the states around the death penalty.
Ngozi, this is all just fascinating to me. It's something that we need to think about more. I'm glad, though, that the advocacy work that's happening is, winning, and we're seeing states say that we're not going to do this anymore. But my goodness, we still have so much work to do. Appreciate all of your insights on this. Ngozi Ndulue, Deputy Director of the Death Penalty Information Center, thank you so much for being here and for sharing with us tonight on Amplified.